Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. How you doing there, everybody? Okay, hey, we're here today to go ahead and dig a little deeper into the Brendan Dassey polygraph. Okay, you guys know I did a live last night. After mine, Allie went live and went all night until like 9 o'clock this morning or something. Anyway, we were talking about, this was the issue we were talking about because we just heard about this because Night Rider and Drizem were tweeting about this and stuff. So I have now here an article by Cornell University for you folks to look at, which goes over polygraphs, what's, you know, the standards for them and those sort of things, and then their analysis of what went down with Brendan and that sort of stuff. So I hope you guys are going to find this to be interesting. You know, I certainly did. Definitely pay attention when it gets to the target questions that were asked Brendan. Very, very specific questions. And if he's been ruled to have passed the polygraph, I think you'll find it interesting what these questions were. So I'm going to go ahead and we'll get into it now. Here we go. You guys can see the article and get all the information about this here. So here we go. All right, folks, here we go. This is an article from Cornell University Law School, Social Science and Law. This is about making a murder. This is about Brendan Dassey's polygraph. So this is going to be, you know, the information about it, the real deal. So we're going to go through this. It's going to explain a lot of things about polygraphs in general, how they're used, how they're given, how they're interpreted. So we're going to go through kind of a lot here today. Hope you guys, can stick around for it. So here we go. The use of the polygraph test for Brendan Dassey in Making a Murderer, compiled by Alana Dallager, Timothy Darby, Christina Lee, and Matt Madsen. So, introduction. Brendan Dassey's polygraph interview is an easily overlooked aspect of Making a Murderer. While it played an integral role in Dassey's confessions and his relationship with his attorney, the polygraph interview was not done ethically. This paper explores how polygraph interviews work, their admissibility in court, how it was employed in Brendan Dassey's case, and how testing is done on children with those of low IQs. Part 1. The history of the polygraph test. Modern polygraph machines were developed in 1921 by John Larson, a UC Berkeley educated PhD and police officer. Larson based his machine off of a prototype that only intermittently measured blood pressure. Larson, however, had his machine measure blood pressure and respiration simultaneously in an attempt to identify deception in interviews. It was assumed that any change in these readings could indicate that the subject is lying. Later on in the decade, a scientist named Leonard Keeler modified the machine to include perspiration measurements as well. Keeler assumed that a person who is lying is more likely to perspire, thus a higher reading would indicate a higher likelihood of deception. While there have been many technological developments in polygraph machines over the last 90 years, they have always relied primarily on the same basic measurements and assumptions. Blood pressure, respiration, and perspiration are still monitored, albeit with more sensitive machinery. The assumption that rises in these measurements indicate potential deception remains. The polygraph machine. Okay, so this is just the parts of it and what's all involved with the machine here. So, today, when a subject takes a polygraph exam, he sits in a chair and has a number of sensors attached to him. These sensors measure breathing rate, pulse, blood pressure, perspiration, and sometimes arm or leg movement. A typical polygraph setup includes 2 elastic bands equipped with sensors, one wrapped around the chest and the other wrapped around the lower abdomen. These sensors monitor respiration and changes in respiration rates between questions. A blood pressure cuff is attached to the upper arm, monitoring blood pressure throughout the exam. A sensor is placed on an index or middle finger to monitor pulse. There may be sensors attached to the palms to measure perspiration rates. There are oftentimes sensors placed on the chair to measure movement. oftentimes on the seat of the chair to detect shifting. These sensors monitor physiological responses throughout the polygraph examination. They are displayed simultaneously in real time on a computer screen that the interviewer sees. The readings are saved in a timeline that is later examined to determine whether or not the subject was being deceptive. So, here's all the parts of it, folks. Obviously the blood pressure cuff on the arm. You got the thoracic, the thoracic pneumograph, the abdominal pneumograph, which they were talking about, go around the chest and around the abdomen area. These are the little sensors that would go on the hands to sense like perspiration. So that's what those are. And then this is the little thing that goes on the end of the finger to measure pulse, right? Here's the chair, and then possibly it has movement sensors in the chair to detect shifting. Right. Okay, so we know what that's all about. Right. Okay. Polygraph interviews. Polygraph tests are almost always started with a pre-test interview. The interview is meant to acquaint the subject to the machine, testing procedures, and the purpose and target questions of the test. Subjects should feel more at ease when the interviewer puts the target questions in context, therefore making the test more reliable. Additionally, an established rapport with the interviewer may make the subject more relaxed. Subjects are asked target questions during the pre-test interview and provided the opportunity to give context to their answers. The American Polygraph Association recommends that a trial test asking only non-target questions should be conducted between the initial interview and the test itself. This allows the subject to become acquainted to testing procedures, verifying consent to the test, and improving the accuracy of the test results by beginning to establish baseline readings and relaxing the subject during the test itself. After the pre-test interview and trial test, the actual test begins. This oftentimes involves multiple series of questions, including both target questions and control questions. Target questions those that the interviewer want to get to the bottom of. Control questions are those where both parties know the answer. For example, a control question could be, is today Wednesday? Both the interviewer and the subject know the answer, so it is a given that the subject is being truthful. Right, correct. Control questions are meant to establish a baseline reading of the subject's physiological response to a truthful answer, allowing for comparison to answers to target questions. The further off the target questions readings are from the control questions, the higher the likelihood of deception. That makes sense. When the test involves multiple series, it allows the examiner to ask questions between the series. This question may allow the examiner to clarify test questions to the subject or probe deeper into what the subject is thinking. For example, the examiner may ask, truthfully or not, I'm getting a big spike at one of the target questions. Do you have anything you want to tell me? This allows the examiner to probe into the subject's deception or self-doubt. Whether or not the subject is lying, any information provided can aid the examiner in uncovering the truth. Once the test series are over, the examiner must evaluate the results. The physiological readings for each question, both control and target, are given numerical scores. There is an assumption that higher physiological responses, and therefore test scores, for target questions over control questions indicate deception. Scoring methods may vary, but overarching assumptions remain true through all legitimate polygraph examinations. So, let's see here. There is an assumption that higher physiological responses, and therefore test scores, for target questions over control questions indicate deception. So basically, yeah, what they're saying is if you show more reaction to the actual test questions, the questions where they're actually trying to probe your memory and see what, if you're telling the truth, if you have more physiological reactions during those questions than you do with the relatively harmless control questions, then that's kind of an indicator that you're lying, is what they're basically saying there. So that's interesting. Let's see. Once the test series are, sorry. Polygraph results are strikingly accurate in scientific testing. Aggregated test results of 24 studies indicate a 0.08 rate of false negative reports, people who are lying who pass the test, and a 0.12 for false positive errors, i.e. people who are telling the truth who fail. Inconclusive results are 0.09 for deceptive subjects and 0.13 for those telling the truth. Of particular interest, in the case of Brendan Dassey, many studies in the 1970s demonstrated that both juveniles and low-intelligence individuals may have less accurate polygraph results. Okay, so part 2, the law surrounding polygraph tests. The Fry and Daubert tests. Fry versus the United States was the first appellate case dealing with the admissibility of a sort of polygraph test, the systolic blood pressure deception test, a precursor to the modern polygraph. The court found the systolic blood pressure test to be inadmissible because it lacked general acceptance in a scientific field. This resulted in the Fry general acceptance test, which stated that for scientific evidence to be permissible, the thing from which the deduction is made must be sufficiently established to have gained general acceptance in the particular field in which it belongs. The Fry test would eventually be replaced by Daubert, which stated that Rule 702 of the Federal Rules of Evidence superseded the Fry test. Judges are to focus on the methods and principles the expert uses to reach its conclusions, rather than looking to prevailing wisdom and general acceptance. When considering whether to admit polygraph evidence in addition to reliability of the test and evidence, courts balance the probative value of evidence against its tendency to unduly influence the jury. The current standard regarding admissibility of polygraph evidence in federal and in state court is the same as the standard for admitting other scientific, technical, or specialized evidence, unless there is a specific rule on polygraph evidence. Most state courts use the Fry test for determining admissibility of specialized evidence, while federal courts rely on Daubert. 3 approaches to admissibility of the admissibility of polygraph evidence. There are 3 general approaches to the admissibility of polygraph evidence in criminal cases. The traditional approach is a per se ban on the use of polygraph evidence, either as substantive evidence or as relating to the credibility of the witness. A second approach gives the trial court discretion to allow the use of polygraph evidence if, among other conditions, the parties stipulate to the evidence's admissibility before the administration of the test. A third approach permits the use of polygraph evidence on a case-by-case basis without requiring stipulation, with most jurisdictions allowing their use only when special circumstances exist. So, there is a per se ban on the use of polygraph evidence in the Second and Fourth Circuits. The following states have a per se ban against the use of polygraph evidence in criminal law trial court cases: Connecticut, Kentucky, Maryland, Minnesota, Mississippi, Nebraska, Rhode Island, Tennessee, and Wisconsin. The standard requiring a stipulation of admissibility by parties and counsel has gained support over the years as an alternative to the traditional per se ban on polygraph evidence. The leading case on stipulations for the admissibility of polygraph evidence is State v. Valdez. In Valdez, the Supreme Court of Arizona reversed its longtime ban on polygraph evidence, stating that polygraph testimony should be admissible upon stipulation in Arizona criminal cases. The court then listed the 4 qualifications that must be met to introduce the polygraph evidence as follows. Number 1, the prosecutor, defense counsel, and the individual defendant all sign a written stipulation which provides for the test taker's submission to the test and for the subsequent admission at the trial of the graphs and the examiner's opinion there on behalf of either of the defendant or the state. The trial judge retains discretion to refuse the admission of polygraph evidence. If the graphs and the examiner's opinion are offered in evidence, the opposing party has the right to cross-examine the examiner and the administration of the test and the reliability of the test. The trial judge should instruct the jury that the examiner's testimony does not tend to prove or disprove any element of the crime with which a defendant is charged, but at most tends only to indicate whether at the time of the examination the individual was telling the truth. Further, the jury members should be instructed that it is for them to determine what corroborative weight and effect such testimony should be given. The following states allow polygraph evidence to be admitted where the prosecutor, defense counsel, and the tested individual all stipulate to allow the results to be admitted: Alabama, Arizona, Arkansas, California, Georgia, Indiana, Kansas, Nevada, Ohio, and Washington. The third alternative is more of a case-by-case option. These courts may allow polygraph to be admitted at the judge's discretion after balancing certain competing interests, or only allow the admittance of polygraph evidence for a particular purpose. The Fifth Circuit has moved from a per se ban to a set of factors a judge must evaluate. Admittance of polygraph evidence is strongly disfavored, but is at trial court's discretion in the Sixth and Eighth is at the trial court's discretion in the Sixth and the Eighth Circuit courts. The Seventh Circuit and Ninth Circuit courts are more receptive to the admissibility of polygraph tests, stating that the admissibility is at the discretion of the district court. These case-by-case states include Illinois, South Carolina, West Virginia, and New York. Polygraph evidence in Wisconsin. The use and admissibility of polygraph evidence in the state of Wisconsin is currently controlled by State versus Dean. In the first Wisconsin State Supreme Court case concerning the admissibility of polygraph evidence, State versus Boner, the Wisconsin Supreme Court relied on Fry in making the determination that the systolic blood pressure device was still too experimental and in too early a stage of development to admit as evidence in a jury trial. 10 years later, the Supreme Court reaffirmed its determination that polygraph evidence was inadmissible, even when both parties had stipulated, prior to the administration of the test, that the findings would be admissible. The Wisconsin Supreme Court continued to enforce a per se ban on the use of polygraph evidence in criminal cases until 1974, when the court decided State versus Stanislavski. The Stanislavski court reviewed the per se ban on the admissibility of evidence at the time of trial on the question of an individual's credibility. The court concluded that over the past 40 or so years, polygraph tests had reached a high enough level of standing and scientific recognition that a per se ban on the use of polygraph evidence was no longer appropriate. The Stanislavski court decided to adopt the Valdez conditions, making expert opinion as to polygraph evidence admissible in Wisconsin in criminal cases if the four Valdez conditions are met. The same standards applied for polygraph tests taken by both the defendant and the principal witness. Just 7 years later, the Wisconsin Supreme Court would decide State versus Dean and revert back to its prior position on the admissibility of polygraph evidence, reestablishing a per se ban on the use of polygraph evidence in criminal cases. In eliminating the Stanislavski rule, the court acknowledged that there was a certain amount of validity and reliability to polygraph evidence and that the science behind the polygraph had progressed. But the court felt that the Stanislavski rule had not increased the reliability of polygraph evidence. The Wisconsin Supreme Court also rejected the possibility of allowing a case-by-case determination of admissibility. The court was concerned that the jury might place too much weight on polygraph testimony, and the lack of established standards for the trial courts to follow in evaluating polygraph evidence heightened the court's concern that the burden on the trial courts to assess the reliability of stipulated polygraph evidence may outweigh any probative value that the evidence may have. Lastly, while Dean still largely controls the legality of the use of polygraph evidence in criminal trials, there is the possibility that a narrow exception exists through Wisconsin Statute 301.132 in 2015, which specifically authorizes the use of polygraph tests of convicted sex offenders by the State Department of Corrections. All right. Part 3. How was the polygraph employed in Making a Murderer? Although the Making a Murderer documentary did not specifically feature the polygraph in its application or at trial, it is worth exploring how Brendan Dassey's defense lawyer, as as well as Dassey's investigators, utilized the polygraph in Dassey's interrogations. Indeed, the use of the polygraph test results were a critical part of Dassey's post-conviction trial, and according to Dassey's post-conviction attorneys, these test results were a catalyst for Dassey's incriminating confession to his mother on May 13th, 2006. Okay, so events leading up to the polygraph test. Brendan Dassey's polygraph test took place in his interview with Michael O'Kelly on April 16th of 2006. The events that led up to this test are as follows. On March 1st, 2006, in an informal interview with investigators for Stephen Avery's murder trial, Dassey confessed to the murder and rape of Teresa Marie Hallback. The next day, Dassey was arrested and charged. No, he wasn't the next day. No, it was that day he was arrested. Anyway, that's a little bit not quite right there, but that's okay. For homicide, mutilation of a corpse, and sexual assault. 5 days later, on March 7th, Len Kaczynski was appointed as Dassey's public defender. In his early conversations with Kaczynski, Dassey asserted his innocence despite his March 1st confession and requested a polygraph test to prove his innocence. Kaczynski then found Mike O'Kelly, a private investigator, through internet ads and arranged to have O'Kelly administer the polygraph test on April 16th at the jail where Dassey was being held. The polygraph test. The Making a Murderer documentary never specified the details of the polygraph test, but transcripts from Dassey's post-conviction trials have shed light on this issue. Contrary to standards of polygraph mentioned above, O'Kelly polygraph tests for Dassey included only 3 sets of questions, each of which had 10 questions, and only two out of the 3 sets of questions held relevant rather than control questions. Of the 10 questions in each of the 2 relevant sets, only 3 questions were relevant questions, with the 7 remaining classified as symptomatic. The relevant questions of each set are as follows. In set 1, the relevant questions are: did you help kill Teresa Marie Hallback? Did you help kill Teresa Marie Hallback on Monday, October 31st? Was the body of Teresa Hallback burned in the fire by the Stephen Avery house? Then in set 2, we have: did you see Teresa Marie Hallback in Avery's house? Did you see Teresa Marie Hallback in the Avery house on Monday, October 31st? And did you touch any part of the body of Teresa Marie Hallback? Finally, although O'Kelly claimed to have videotaped the entire polygraph test, he had presumably lost the files by the time Dassey's post-conviction proceedings of his post-conviction proceedings in 2010. He had lost the video, eh? Yeah, sure. The confusion surrounding the results of the polygraph test stems from the fact that it was 3 contradictory interpretations. First, according to Kaczynski, the results of the polygraph test were inconclusive, and the test results were never admitted into Dassey's trial. Second, in the post-conviction trial, Dassey's attorney sought to admit the testimony of Dr. Charles Hauntz, an expert witness on polygraphs, who would have testified that he had reviewed the polygraph charts prepared by Michael O'Kelly and that his analysis of the charts demonstrated that Brendan Dassey passed the polygraph test given to him. Dr. Hauntz's testimony was not admitted on the grounds of lack of relevance. Oh my Lord. I mean, you're trying to prove that O'Kelly's a liar, and then you're going to say the evidence proving that he is a liar is inadmissible, is not relevant. Gee, anybody remember Judge Willis? I'm afraid I don't see the relevance of those deleted voicemails. I mean, how many people here in the criminal justice system in Wisconsin have their head this far up their backside? I mean, seriously. Anyway. Third, despite Kaczynski claiming that O'Kelly had reported inconclusive results, O'Kelly claimed that the polygraph test results indicated a 98% rate of deception. This final interpretation of failure was the result that Dassey received on his May 12th interview with O'Kelly, and this set the stage for 3 major conversations: the interrogation by O'Kelly, the interrogation by Dassey's investigators, and the Dassey phone call confession to his mom. The use of the polygraph test. Between April 16th and May 12th, Kaczynski elevated O'Kelly O'Kelly's involvement from polygrapher to investigator. On May 12, 2006, immediately after Judge Fox admitted Dassey's March 1st confession as evidence, a heavy blow to Dassey's trial, O'Kelly met for an extended period of time with Dassey. During this meeting, O'Kelly laid out photographs of the crime scene and various documents, including Dassey's polygraph test results. This was the first time that Dassey saw the test results. O'Kelly asked Dassey what he thought of the 98% on his polygraph chart meant, and Dassey's guess was that he had passed. O'Kelly then told Dassey that the results showed with 98% certainty that Dassey had been lying during the polygraph test. He tells Dassey 98% that he was lying. He tells Len Kaczynski that it was inconclusive. I mean, this guy O'Kelly, man, unbelievable, this guy. He's off the chart. The polygrapher turned investigator then gave Dassey forms to fill out about his involvement in the crime. O'Kelly used the failure of the polygraph test over the next few hours to guide Dassey into changing his responses on the forms until Dassey had told what O'Kelly deemed to be the truth. In one form, Dassey was forced to check a box between the options, I feel sorry for what I did, and I do not feel sorry for what I did. When Dassey wrote an initial response proclaiming his innocence, O'Kelly made him rewrite his response, including a detailed description of the events. O'Kelly then carefully instructed the teenager to draw certain pictures of the crime, including images of rape and of the victim chained to the bed. So this is it. Brendan's maintaining his innocence. This is the investigator hired by his attorney, and this is the paper that he's forced to sign here. You see this? You have to check one of these boxes. So I am very sorry for what I did, or I am not sorry for what I did. You understand, folks? He's not given an option to proclaim his innocence there. O'Kelly is clearly railroading him, lying to him about the polygraph, giving him this form to fill out. So disingenuous. I mean, unbelievable, right? This guy O'Kelly, man. I gotta say, man, if I was him, I'd be fearing meeting my maker. Put it that way. Survey from O'Kelly interview. Right, yeah, that's the paper. So, using the crafted confessions from his meeting with Dassey, O'Kelly immediately reported his interrogation results to Kaczynski and scheduled an interview with Stephen Avery's investigators for Dassey the following day. Dassey's lawyer, Kaczynski, was informed of the meeting but chose not to be present. Throughout the meeting, Dassey remained confused and unclear in his responses to questioning. This interview led to Brendan's confession over the phone to his mother that evening. Brendan's trial took place from April 16th to April 27th of 2007, and he was found guilty of all three charges. On August 2nd, 2007, Dassey was sentenced to life in jail with possible parole opportunities beginning in 2048. In 2010, Dassey's post-conviction lawyers fervently argued that O'Kelly had used the polygraph test results to coerce Brendan to confess in 2006. Judge Fox denied Dassey's motion for a new trial, and his decision was upheld by the Wisconsin Court of Appeals. Part 4, polygraph testing in juveniles and those with cognitive impairments. And then this is just going to basically go on to say, talk about how, here, let's just talk about it. There are two immediate issues that spring to mind when we think about using the use of polygraph testing in making a murderer with regard to Brendan Dassey: his age and his intellectual disability. These two issues are interrelated. Young people and people with mental impairments have cognitive abilities that are different from the neurotypical adults. At the same time of the crime, Brendan Dassey was 16 years old. He was also, as reported in the documentary, in special education classes. His IQ has been reported to be between 69 and 73. This is a fairly significant impairment. Adults are considered eligible for disability benefits by the Social Security Administration if they have an IQ score under 60. A person with an IQ of 60 to 70 may be considered eligible if they have another mitigating impairment. This means that the Social Security Administration considers adults with IQs of less than 60 unable to work. Brendan Dassey's IQ is thus a significant factor in the interrogation techniques used in interviewing him, including the use of the polygraph testing. There is a paucity of studies regarding polygraph use in juveniles and also in people with intellectual impairments. This can surely, in part, be attributed to the legal trends as identified earlier in this paper. Polygraph tests are rarely admissible in court. However, As we saw in Making a Murderer, polygraph testing is used to facilitate confessions. And as we saw in the show, many people view polygraph testing as a sort of be-all and end-all. Brendan himself requests that a polygraph test be administered in order to prove his innocence, and his lawyer complies. In a study published in 1983 by the Office of Technology Administration, an overview of the research seems to suggest that the polygraph tests, when looking at the variable and intelligence alone, are actually more accurate when used on people of lower intelligence. Suggests that polygraph tests, when looking at variable intelligence alone, are actually more accurate when used on people of lower intelligence. And the way that Steve Drizzen says that is somebody, a guileless individual, like, the lack of guile in Brendan. A guileless individual like Brendan is basically incapable of beating the machine. He's not. It's not something that's in his wheelhouse. So that means that when somebody like Brendan, of that limited intelligence and stuff, passes a polygraph test, it's generally a little bit more solid than it would be for somebody who's of a bit higher intelligence. So that's basically what they're getting at right there. This report acknowledges that there are a few academic studies regarding this specific issue, and it further acknowledges that much of the work equates intelligence with education level. Further, the work seems to attribute a tendency and ability to lie with high intelligence, which seems to be a tenuous connection. This paper does spend a lot of time on the importance of setting and environment in the administration of polygraph testing. It also cites studies that seem to equate the admission of socially undesirable attitudes with accuracy of the lie detector test. This seems like a potentially dangerous conclusion, especially when presented with juvenile offenders like Brendan, who, as we saw in the documentary and as will be seen in the presentations about false confessions, are more prone to give answers that they think will please their examiners. In watching Making a Murderer, the coercive nature of the questioning that is used on Brendan, both by police and ultimately by his own lawyers, is striking. In 1981, the Fifth Circuit Appeals Court addressed the issue of using polygraph testing to elicit a confession with an adult subject who was mentally impaired. In Henry v. Dees, the facts concerned a polygraph test agreed upon by the prosecuting attorney and Mr. Henry's defense team. Henry was a 20-year-old man who was classified by the state of Louisiana as a marginally mental retardate. He was charged in state court with armed robbery. His defense team and prosecutor reached an agreement that Mr. Henry would undergo a polygraph test. If he passed the test, that is, if he was found to be truthful in denying his involvement in the crime, the prosecutor would drop the charges. If he was found to be lying, the parties agreed that Mr. Henry would plead guilty. The examiner told Mr. Henry that he had failed the test outside of the presence of counsel, and before the conclusion of the polygraph test, this led Mr. Henry to provide his examiner, a police sergeant, with incriminating evidence, which was then introduced at trial. In the case of Mr. Henry, raised two issues, both of which seemed relevant to the case of Brendan Dassey. The first was the deviation from standard examination procedures used by the police sergeant administering the test to Mr. Henry. The second issue was, given Mr. Henry's mental impairment and the utterance of incriminating statements outside of the presence of counsel, whether Mr. Henry could really waive his constitutional rights and thus agree to plead guilty. So basically, can you trust what's coming out of Mr. Henry's mouth? Because obviously, his mental impairment and stuff makes him inclined to potentially tell the investigators what they want to hear, or what he thinks they want to hear, whenever they start coming down on him, right? So that's what they're saying. That's what applies to Brendan. Whenever Brendan thought that the investigators were coming down on him, he was like immediately wanting to please them and tell them what they wanted to hear, right? The district court ultimately overturned the previous court's denial of a petition for relief. The opinion states, even assuming that Henry could meaningfully grasp his constitutional rights so as to admit of a valid waiver, we are not convinced he knew or could understand the range of scope of proper polygraph examination questioning. This point seems especially relevant to the case of Brendan Dassey, wherein he asked his defense attorney for a polygraph test. Despite this fact, the court in Henry seems to be implying that a polygraph test might not be a proper examination vehicle for a person with a low IQ. The Henry decision also addresses the issue of misrepresentation by examiners of test results when explaining them to the test subject. Although the examiner in the case was a police sergeant and Brendan Dassey's examiner was an investigator hired by his defense team, the principle of the matter remains the same. Misrepresentation of results by examiners can affect the overall result and lead to a false, coerced confession, which are not admissible in a court of law. This case does not seem to set state or federal standard. However, a cursory review of legal cases concerning polygraph testing in individuals with low IQs would seem to suggest that state courts across the country agree that people with mental impairments who submit to polygraph testing and subsequently confess, absent coercive circumstances as found in Henry, that is, deviating from standard testing procedures and questioning outside of the presence of counsel, do so voluntarily. The consensus seems to be that there is no Miranda violation inherent to use the polygraph testing in people with low IQs. Juvenile cases seem to toe much the same line. As those of us who took criminal procedure are surely aware, much of the case law concerning juvenile interrogation, and thus polygraph testing, has to do with definitions of custody and voluntariness. In 2006, the Ninth Circuit Court of Appeals heard a case wherein a juvenile argued that, although he had consented to a polygraph test, the post-polygraph questioning was involuntary because he did not specifically consent to it. Though he was not a juvenile, the Ninth Circuit did not find the need for a separate rule for juveniles that would require a warning for these post-polygraph questions, and instead held that previous decisions which found that adults did not require a separate waiver for post-polygraph questioning also held for juveniles. There has not been much academic study of the use of polygraph testing in juveniles or people with significant mental impairments. The studies that do exist do not suggest that polygraph tests are less accurate on juveniles or those with low IQs. Rather, the issue is that these populations are more vulnerable to coercive interrogation techniques and less able to understand their constitutional rights with regard to self-incrimination, and polygraph testing may play a significant part in eliciting coerced confessions. Conclusion. Brendan Dassey's polygraph interview was clearly mishandled. It was used in a coercive manner by Dassey's own counsel to elicit a confession. Brendan could not grasp the complexity and the seriousness of a polygraph interview, as he was a minor with a low IQ, while appellate courts have done nothing to address the maladministration in Dassey's case. It was clearly done incorrectly. It should serve as a cautionary tale for any defense counselor looking at subjecting his client to a polygraph, especially if the client may not be able to consent. So that's what it comes down to, folks. This, the Cornell, as I said, the Cornell University Law School here, social science and law. I mean, they looked at this and basically they agree that what O'Kelly was doing was just absolutely ridiculous. I mean, just absolutely off the charts. And the way and I like the way they word that in the conclusion, that this needs to be addressed, because we need to have, something, a cautionary tale to prevent defense lawyers from doing what Len Kaczynski did here. So that's basically what was going down with Brendan's confession, or Brendan's polygraph, folks. Want to just look back at these questions again, because look, he has been determined that he passed this polygraph. Look at these questions they were asking, folks. They're pretty freaking specific. Did you help kill Teresa Marie Hallback? Did you help kill Teresa Marie Hallback on Monday, October 31st? Was the body of Teresa Marie Hallback burned in the fire by Stephen Avery's house? Did you see Teresa Marie Hallback in Avery's house? Did you see Teresa Marie Hallback in Avery's house on Monday, October 31st? Did you touch any part of the body of Teresa Marie Hallback? Those are the 6 questions, the target questions that were asked to Brendan. And he has been determined to have passed the polygraph test. And it's just shocking that Kaczynski and O'Kelly were able to get away with this and were able to go on with their lives, because Brendan sure didn't. All right, so there we are. That was, a pretty comprehensive look at what went down with that polygraph test for Brendan, and the tactics being used by O'Kelly, the just unconscionable behavior of Kaczynski. Essentially derelict in his duty, really. No other way to really look at it. I mean, it's just ridiculous. And this article continues to point out that it's because of O'Kelly and Kaczynski that Brendan gets thrown into with the Avery investigators, which are Wiegert and Fassbender. And then from there, they bully him and coerce him into calling his mom on the prison phone and saying what they want him to say there. So it's recorded, right? So it's just like unbelievable. But I hope that was helpful for people. A more comprehensive look at, what happened with the polygraphs, the issues around polygraphs, how they're admissible, why they're admissible, why they're not admissible, and that sort of stuff. So hopefully everybody has a little bit better understanding of polygraphs now. I just want to go ahead and keep talking about this, the fact that Brendan Dassey asked for a polygraph test, which Reed, the people who designed the interrogation technique used by most law enforcement, right? Reed themselves will tell you that when a suspect is insisting on a lie detector, that's generally an indicator of innocence. They're not saying it's always, but it's generally an indicator. You know what else is an indicator? When that person insists on taking one and then passes it. Especially when that person is a guileless person, as Stephen Drizzen would say, like Brendan Dassey, and they're just completely incapable of beating the machine, right? So, I, just wanted to go ahead and give everybody a little bit more information about this. So, I hope you guys enjoyed it. If you haven't already, please hit subscribe, and we'll see you